To the campus of North Idaho College and today's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Good afternoon, ladies and gentlemen. Today I welcome you to show number 2 of a 6-week series dealing with the topic Know the Law. I would like to once again recognize the Kootenai County Bar Association for their fine work in helping us put this together. Our subject today will be Bankruptcy Overview, and it will be followed in future weeks by such issues as consumer purchasing. We'll have a week on wills and estates and several other important topics. We think this will be of great value to you, and we hope you'll be with us each week during this 6-week period. In order to discuss today's topic, I'm happy to welcome to our program 2 guests. First of all is Mr. Jack Spurgeon, who since 1974 has been a federal Chapter 13 trustee for the state of Idaho. He's also a former state legislator in Idaho. Welcome, Jack.
Thank you, Tony.
Our second guest is Richard Wayne Sweeney, who is an attorney in Coeur d'Alene. He specializes in work for creditors, banks, and other financial institutions, and about 50% of his work is in the field of bankruptcy, and so he's certainly a specialist in this area. Welcome to our program, Wayne.
Thank you, Tony.
I'm also happy to welcome back today the person that's helping me with this series, Mr. Bob Brown, who's the Assistant Vocational Director at North Idaho College, and I will invite Bob to commence the questioning.
Thank you, Tony. I read recently in the paper that bankruptcies were at an all-time high, and I'd like to have each of you gentlemen comment, if you would, on why do you think this is happening? Do you agree with that statement? And what are some of the reasons that this is happening in this country at this time? And Jack, I don't know, maybe start with you.
Well, thank you, Bob. They are at an all-time high, about 40% more than they were last year, and up approximately 40% from the previous year. So they are at an all-time high, and I think in the Wall Street Journal that they're running over 500 business bankruptcies a week. So they are, without doubt, at an all-time high. The causes, consumers have quit spending and businesses are having problems. Basically, interest. High interest has been the real problem, coupled with inflation and loss of jobs. You can look in the Spokane or look in the Shoshone Valley and see it. And of course, I travel the 10 northern counties, and I see a lot of it in Lewiston now, where I didn't see it several years ago. And we're starting to see farmers, small farmers that are having real troubles, loggers, contractors, trucking industry, all of them having a real tough time. And it stems from consumers not being able to buy, and nobody spending any money, and high interest rates.
Yes, Bob, I think Jack has pretty well nailed down the state of the situation in not only Idaho, but in the nation as well. Idaho has traditionally, at least in the last 10 years or so, been a state which has suffered a relatively high bankruptcy rate per capita. In fact, during the 70s, according to a report in the American Bankruptcy Law Journal a few years ago, Idaho's rate was just about double the national average. And that is because of the economic situation, the high growth, the lack of an economic base in Idaho to support the high growth with jobs and so forth. Presently, Idaho's bankruptcy petition filing is substantially above all previous record filings. I think this year is going to set a new record over and above last year, which set the record. And of course, that reflects the situation nationwide. I think that the reasons for the substantial increase in filing are due to, in part, to the downturn in the economy, but also because of aggressive and expanding credit in the 1960s and 70s, when this economy was essentially one which was credit-based. I think the lenders were aggressively lending. Some of those loans were not serviced properly, were not extended properly. Likewise, I think that the consumers took on far more debt than they could realistically hope to service. As a result, when one spouse might become unemployed or suffer a cutback in job hours or something like that, it would naturally cause some economic dislocation there. And as a result, and also because I think to some extent because of the changes in the bankruptcy law, which went into effect in 1978, had some impact, not as much as some critics have said, but has had some impact on the number of filings we see now.
Gentlemen, I think that our viewers would be most interested in the procedures that are involved in this. I just sense that they're saying, well, what encompasses bankruptcy? What can you do, and how do you get out of a difficult situation? Wayne, you just mentioned the fact that the Bankruptcy Reform Act of 1978 was passed and went into effect in October 1979. Would you please take a few minutes to explain to us what changes this has brought concerning both the creditor and the debtor, and how this affects what can happen in Idaho or any other state?
Yes, the Bankruptcy Reform Act was passed by Congress in 1978, and it represented a whole-scale overhaul of the bankruptcy law. The preceding bankruptcy law had originally been enacted in 1898, had a substantial revision in 1933, but essentially we had had the same bankruptcy law for over 70 years, and it was quite outdated in light of the changes that had taken place in a credit-based economy, which we had. I think the principal effect of the 1978 Bankruptcy Act on consumers has been the changes in the Chapter 13 of that title of the Bankruptcy Code. Chapter 13 is what was known under the Bankruptcy Act as the wage earner plan. After the enactment of the new law in 1978, this provision had many benefits which made it more attractive to anyone with regular income to attempt to work out a payment arrangement with his or her creditors, so long as the individual had some source of regular income, and it didn't have to be from salary or wages as it had to be under the old law. That person could propose some plan to pay some amount back to the creditors over a period of time. Usually and traditionally it's 36 months. Moreover, the debtor could also arrange to restructure the debtor's secured debt. For example, an obligation secured by an automobile or even a house in some cases could be restructured so that the debtor could bring the payments more in line with what the debtor could afford. And usually this took the form of reduction in the amount of the monthly payment and extension of the payment over a period of time. I think that has been the most attractive feature of the new bankruptcy law. Certainly, I think the number of filings under the law have reflected the fact that the vast majority of them have been under Chapter 13. The debtors are taking advantage of this opportunity to keep their property, the collateral that secures the debt, essentially cram down a payment schedule on the secured creditor in that way, and ultimately get a discharge, a very broad discharge. So
that's what you'd consider the consumer's advantages to the new law.
Yes.
In other words, they're in better shape. They can keep more than they could under the old law and continue to function financially in a more adequate way for themselves and their family.
Yes, under Chapter 13, the debtor generally keeps all of his property. He must set up a plan to pay some amount of money to his unsecured creditors, and can make a plan of arrangement with his secured creditors in such a way as to retain his collateral. And generally the standards or provisions for doing that are flexible enough that most debtors are successful in proposing a plan. Now, under the other chapter of the Bankruptcy Code, which is commonly known as the Straight Bankruptcy, the debtor does not necessarily get all those advantages. He may lose his property, for example. He does not have the right to force a particular debt restructure with a secured creditor. If, say, GMAC has a security interest in the debtor's automobile, the payments are $200 a month. if the debtor files a Chapter 7 proceeding, the debtor may have no choice but to pay GMAC $200 a month if he wishes to keep his car.
Otherwise, he loses the car.
That's right. And in Chapter 13, he can propose a plan that, within certain parameters, can reduce the payments to GMAC, say to something like $150 or $125 a month over a period of time, extend the payments out, and keep the car and reduce the payments. So there's that type of leverage which is available with Chapter 13 debtor. Another great advantage of Chapter 13, and again this doesn't come up too often, but it's the broad discharge. The Chapter 13 debtor is entitled to a much broader discharge than the straight bankruptcy or Chapter 7 debtor, as we call him. Chapter 13 debtor, if he successfully completes his plan, can discharge any type of debt except for taxes, alimony, and support. But any other type of debt, whether it be for embezzlement or malicious destruction of property or fraud, such debts as would be non-dischargeable in a Chapter 7, a straight bankruptcy. In other words, the debtor would ultimately have to pay those debts, even if he's going through a bankruptcy proceeding, could still be discharged in Chapter 13. That's what we call the super discharge.
In other words, he would not be responsible for paying those at some later date if he goes through the bankruptcy process.
If he successfully completes a confirmed Chapter 13 plan.
With the exception of those three things you mentioned.
Yes, taxes, alimony, maintenance, and support.
Bob Brown.
Jack, let's say that I'm married, I have 2 children, I've been laid off work for 6 months, my house payment is 4 months behind, my car payment is behind, my bills are stacking up, and I decided that the only way out for me is to declare bankruptcy. Who do I go see? What do I do?
Well, first of all, you probably talk to an attorney, or maybe even one of your creditors might even send you to an attorney or to a trustee. And since I'm the only trustee in the 10 northern counties, I receive a lot of telephone calls and do a lot of interviewing of people about their cases. What you can do if you have regular income, be it from unemployment or Social Security or gifts, grants, any type of income that you may have, you can file Chapter 13 and pay the real value of the vehicle that you have over a period of 3 years and possibly longer if the court decides. Also, the arrearage payments on your house can be brought into the plan, and you can make up those back payments over a period of 3 years. So it does give you some advantage that they can stop the foreclosure action if they're foreclosing, and you have to meet those payments because as a trustee, I am bound by law to see that those payments are made, and if you don't make the payments, then I seek a dismissal and throw you back to the creditors to deal with them. And that's basically what a 13 can do for you under those circumstances.
And your suggestion was not to contact you directly, but should you go to an attorney first?
That is correct, yes. They can contact me if they want to, but then if they don't have an attorney in the area, Bob, I just give them 3 or 4 or 5 names. I don't give them Wayne's name, but I'll give them other attorneys' names, and then they can contact them.
Okay.
And let me comment on that. I'm sure the reason Jack would not give a consumer my name, and I think it's an important point to mention, is that not every attorney handles or is really competent to handle debtor representation and bankruptcy. This is a very technical area of the law. It has its own rules of procedure, its own special substantive law, and again, since, as was mentioned at the outset, I restrict my practice somewhat, so I would not take debtor representation. On the other hand, the general practitioner may not take debtor representation for that reason.
I would like to remind our viewers that if you've tuned in late to our program, we're in the second of a 6-week series on Know the Law. Our subject today is Bankruptcy Overview. We have 2 guests. First of all is Mr. Jack Spurgeon, who's a federal Chapter 13 trustee for 10 northern counties of Idaho, and Mr. Richard Wayne Sweeney, who's an attorney specializing in the field of bankruptcy. Wayne, I'll go back to you. I believe it's your turn anyway. I've been listening to both of you, and it sounds like from what you're saying that if in a little bit of financial trouble, the great advantage is to declare bankruptcy under Chapter 13, and you seem to solve your problems. I suspect it's not quite that way completely. What I'm asking is, suppose you do go through Chapter 13 and you declare bankruptcy and you work out certain things. What are some of the consequences that might be negative. In other words, my question is it, if at all possible, better not to declare bankruptcy? Does it have any effect upon your record in the future?
Well, I think it does. Of course, that is very much on a creditor-by-creditor basis. How a particular lender might look at a future application from one who has filed a petition and or received a discharge in some sort of bankruptcy proceeding. It may be indicative of inability to handle credit. That's generally the reason why it may reflect adversely on a person's credit rating. Now, certainly another disadvantage is the uncertainty over what's going to happen with the debtor's affairs and property. Once a petition is filed, then the debtor's property and his entire financial background is subject to review by the trustee and on occasion the bankruptcy judge. There may have been transfers that of property which may be recovered in the bankruptcy proceeding back for the property may be recovered back for the benefit of what's called the estate or for distribution to other creditors. A debtor may not receive a discharge, particularly in Chapter 7, if there's been improper conduct. As a result, he may stand to lose all his property and not receive a discharge. So that there are still disadvantages to filing. It's not nirvana by any means. It is a way out. Certainly, I think that lenders and financial institutions, by and large, prefer to have a consumer contact them if the consumer is in trouble and try and work something out. It's been my experience that the lenders do go to some lengths to try and accommodate a debtor. In some cases, there may be a refinance loan or something that can be made, or other extensions that can be made through an individual lender. So I certainly don't advocate that every consumer who finds himself, or not only a consumer but any business debtor or otherwise who finds himself in financial trouble, to go to a bankruptcy attorney. But I think that the first step should be to contact the lender and the creditors that individual is having difficulty with, whether it be, again, a business creditor or a consumer creditor, but to contact those creditors and explain the circumstances. If the business is bad for this season, or some other misfortunes happen, to explain that, try to get an extension, try and reach an understanding with that creditor, and only as a last resort consider the bankruptcy option.
Jack, we were going to have may I go ahead and then I'll have a question.
Well, just you were asking about if there were some advantages to filing Chapter 13, and there very definitely are quite a few advantages. Number one, you can probably lower your overall payments over a period of time. Number two, that if you go into a Chapter 13, your credit bureau files reflect that type of situation for 7 years, not 10 like it does in the Chapter 7. If you've completed at least 2 years of your plan and you otherwise qualify, you can generally get housing through HUD or Idaho Housing or Fannie Mae or whatever it is. And probably the most important, as far as I'm concerned, is bondability. If a person files a Chapter 7, I've never seen a bonding company accept them yet. But at the same time, I've never seen them turn down a person that's bondable under a 13. So now I'm not going to say that they won't in the future, but at least they haven't as yet.
Jack, in your work with Chapter 13 clients, I'm a little confused, and I think our viewers are too. You've advocated, the two of you, going to the creditor and going to an attorney and coming to you and so forth at that point. The courts get involved in this, and one of our guests was snowed in a plane today and could not be here. But there's a federal judge for the state of Idaho, for example. Other states have them too, bankruptcy judge. So from you, does it go into court, and this final agreement and resolution has to be made in a court by this federal judge in cooperation with your office? Is that correct?
That's correct, Tony. He makes the final decision on confirming the plan, and he determines. Excuse
me, you work it out with the individual.
The attorneys, the attorneys and the debtor and myself, as a general rule, work out the plan, along sometimes with Wayne, where he's objecting to a plan because his creditors are not being treated fairly, or at least he thinks they're not. And so between the 3 or 4 of us, we'll determine that a plan is feasible, and that the creditors are being paid properly. And then the final decision is up to the judge to confirm the plan. And once he confirms that plan, then the plan is binding on all parties. And you have to go back to court over lifts of stay and other things if you want to overturn the plan or some other reason.
Does this create additional costs for the debtor in this case? They have to pay the attorney's fees, etc.?
Well, the attorney's fees that they charge differ because attorneys look at this thing in a different manner, how far they have to travel, how much work they have to do, and this sort of stuff. And I might say that there's a $60 filing fee for Chapter 13 or bankruptcy. So it's one thing that has to be paid in advance without any problems. But the judge is the final word on the plan.
Bob Brown.
Wayne, the Bankruptcy Reform Act of '78 that you have talked about seems to have quite a few advantages for the consumer, for the debtor. Number one, are there some advantages in that Reform Act from the creditor standpoint as well, and if so, what are they? And then secondly, do you anticipate any, there seems to be a lot of legislation at the national level now, perhaps in some areas like environmental law and so forth, sort of going back and taking a further examination of some of the things that were done in the 70s. Do you anticipate that there be some changes in the bankruptcy law to tighten up some of these advantages to the consumer?
I think creditors generally feel that the Bankruptcy Reform Act of 1978 essentially left them out in the cold. It was, in my view, the Bankruptcy Reform Act was a result of years of pent-up efforts to reform the old act, which I said had been in place for over 70 years. And there were various efforts at reform which were initiated through the Congress, supported largely by consumer interests in the early 70s. And these efforts were largely frustrated and blocked by certain creditor interests. The creditors were quite satisfied with the old act and quite frankly did lobby against certain changes, many changes in fact. So when the lobbying efforts, the obstructionist efforts went to the wayside, and they went to the wayside because of the retirement of a corporate attorney for one of the major financial institutions who no longer was there to be active in Congress, the reformists just pushed right through and got the changes in place which were very much consumer oriented. And as a result, I can't think of too many advantages at all that the Bankruptcy Reform Act of 1978 provided for creditors. The only some advantages I can think of would be to what we call codify some provisions of the law as it relates to determining secured claims and rights of creditors and that sort of thing. The old act was somewhat vague on some provisions as to the rights and that creditors had. A lot of that had developed in the judicial or case law, as we call it, and that was codified and set down in the black letter in the Bankruptcy Reform Act. But very few advantages to creditors were offered in the Reform Act, which of course brings us to your second point, which is what about the changes? Well, there is and has been ever since the recession got going in 1980 intensive efforts in Congress to modify the law, to amend it, to reduce some of the advantages that were perceived to be there for the benefit of the creditor and I mean for the debtor, and to modify, for example, the Chapter 13 provisions to require that a specified amount be paid to creditors before a discharge can be entered. Now there's just a floor for payments to unsecured creditors, and that floor is asked to be at least as much as a unsecured creditor would receive in a straight bankruptcy proceeding, which is generally his pro rata amount of the debtor's non-exempt property, whatever that may be. In a lot of cases, the debtors have no non-exempt property, low-income debtors, for example, and as a result, if there's no non-exempt property, then the unsecured creditors receive a very nominal amount. So there have been efforts along that line to change it. There are also efforts to protect special interests from such as stockbrokers, such as grain dealers and that type of thing from the some of the provisions of the present code. So those efforts are underway, and of course the present situation only exacerbates those efforts to make the changes, and I'm sure we'll see some.
Thank you.
We're running very short on time, but two areas I'd like to get in quickly. Wayne, you and I were discussing before the program the other day that the federal government does allow a state to exempt itself from the more liberal personal property exemptions, and Idaho exempted itself, I believe, in March of 1981. Could you just briefly tell us how that affects individuals in Idaho?
Yes. In the Bankruptcy Reform Act of 1978 had its own set, still does have its own set of exemptions which an individual in any state who wishes to file a petition may claim to protect his property. Now, exempt property is unavailable for liquidation to satisfy the claims of creditors. So the more exempt property a person has, the less the creditors would receive in any type of proceeding. Again, in response to the last question, I pointed out that the creditors in a Chapter 13 petition, the unsecured claims receive a pro rata distribution of the amount of non-exempt property which is available for creditors. In any event, there was a strong feeling that the bankruptcy code exemptions were too liberal. Certainly the business community felt that, and there was a provision in the code which allowed the states on a state-by-state basis to opt out to have those exemptions not apply in the state of Idaho, and the Idaho legislature went along with that as an emergency effort in March of 1981. At last count, 34 of the 50 states have also opted out. As I recall, our neighbors Montana and Oregon have both opted out, but I believe Washington still has the federal exemptions.
Jack, I have a final question for you too. The effect of this trend we're talking about the last 2 years, you mentioned at the beginning of the program, the rise in bankruptcies. What's that going to do to the future lending, do you think, for debtors in the country?
Well, I don't think it's going to change too much because I think most financial institutions lend on the theory that if the people have good, have ample income to pay their debts, that they would go ahead, ample income and ample, what am I trying to say, collateral, that they would go ahead and lend them money. And,
but for those who are not having very high incomes, now that the creditor may not get as much as he would under the old law, it might be more difficult for those people. Would that be correct?
Well, it's difficult now, and it always has been difficult, and I think it's going to be worse.
I'm sorry to interrupt. I'm sorry we're out of time. Okay. I want to thank both of you for coming, and I want to thank Bob Brown for his questions. It's been a very informative program, in my opinion. Ladies and gentlemen, I hope you'll be with us again next week, and we'll continue this series. And on the third program, we will talk about consumer purchasing, and we'll deal with such areas as solicitations at homes and rights you have in that case. As I've indicated, we have 4 more programs, and I really believe that you'll find those, each one, very helpful to you in dealing with legal matters and legal problems. I hope you'll be with us. Please have a good week. I am Tony Stewart.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.